the third technical session on drafting and pleading in the era of faceless assessments, appeal and faceless ITAT. The session will be delivered by Senior Advocate Shri Tushar Hemani, sir. I request Advocate Hiren Vakil, Chairman of Media Committee, and CA Jayesh Moore, Chairman of Publication Committee, to escort the dignitaries CA Shivam Bhavsar, Co-Chairman Stage Committee, CA Maulik Patel, Committee Member ITBA, Advocate Anil Shah, Chairman South Zone AGFTC, Advocate Maulin Shah, Chairman Central Zone AGFTC, Advocate Mahendra Swami, Chairman North Zone AGFTC, CA Rutvich Shah, Committee Member AGFTC, along with our eminent speaker, Senior Advocate Shri Tushar Hemani, sir, on the dais. Let us all welcome the dignitaries with a huge round of applause for the final session, the third and the final session for the day. We are delighted to have Shri Tushar Hemani, Senior Advocate. Shri Hemani sir's extraordinary professional achievement is that he has been conferred the title of being a Senior Advocate from Gujarat High Court at a very young age. I request Advocate Hiren Vakil, Chairman of Media Committee, to welcome Shri Tushar Hemani with a book. And I also request CA Jayesh Moore, Chairman of Publication Committee, to welcome him with a memento. Before I invite Senior Advocate Shri Tushar Hemani ji, I would like to throw light on his professional achievement. Honorable Senior Advocate Shri Tushar Hemani ji is a successful advocate, successfully argued matters related to direct and indirect taxation, corporate, commercial and fiscal laws before Honorable Supreme Court, High Courts, various tribunals, commissions and appellate commissioners. He is the past president of ITAT Bar Association. He is a regular writer of columns and articles in various professional journals and conferences. He is a regular speaker at various conferences, seminars and meetings of various professional bodies and a visiting faculty at various institutes, universities, colleges and management and law schools on the subject of taxation and corporate laws. Let us all please welcome with a huge round of applause Honorable Shri Tushar Hemani ji. Sir, I welcome you for your address.
Good evening, friends. Must be a long day for all of you. And this is a new habit which we'll have to cultivate, particularly coming from COVID times, where we all are used to me delivering lecture, sitting in the comfort of my home, and you people listening to the same in the comfort of your home. In fact, I was just talking to someone that after a long time, I'm delivering a lecture with full clothes and shoes on. Otherwise, we usually put on, something which is fancy on the upper part of the body. Lower part, we usually try to, wear the track pants, shorts, etc. And shoes are strict no-no. So, a different experience. In fact, incidentally, in March, probably last year it was 7th and 8th March. 6th and 7th March, yes. Then that was the time when I delivered the lecture in front of the crowd. And thereafter, after exactly a year, again I'm here delivering a lecture before living human beings instead of a screen, monitors. And nowadays the practice is that people usually switch off the videos. So you don't get to see anyone except your own face when you are delivering the lecture. Sounds so mechanical. But now, with this human touch, probably we are in a better environment. It's a small crowd, probably we can make it an interactive session. So in case if during the course of the lecture, if you want to ask something, just raise your hand, we'll pause, discuss, and then move on. I'll also try to make it as light as possible, so that I know the last lecture of the day is always taxing. And the subject also is taxing. In fact, I was just going through the book which was given to me, Think Like a Monk, Live Like a Monk. A very appropriate book. Whoever has selected the book, I must give him the best compliments. We are all going to be monks, because the way in which government is changing the provisions, the way in which the entire law is going to be now implemented, the days are not very far that we will start living like a monk, in a faraway places, because we don't have to visit the income tax department, we don't have to go there personally, and we have to keep on doing the karmas. આપણે કહીએ તેમ કે કર્મ કરવાના ફળની આશા નહીં રાખવાની, રિટર્ન સબમિશન બનાવે જવાના, અપલોડ કરે જવાના, પછી વિચારવાનું નહીં કે એમાં શું થવાનું છે. Friends, I was in fact going through, I was going through the entire law on the issue while trying to figure out as to how do we deal with this issue. Something caught my attention in the process. Can we go to slide number 5? Some of the sections providing, yes. Look, what is happening is, let us try to understand, before we actually go to the submissions and pleadings and presentation part, the way in which the entire act is implemented, right from 1922 to 1961, and right from up to 2020, or I would say 2019, when the e-assessment scheme was first launched. Till that point in time, everything was physical. There was no concept of virtual hearing, or there was no concept of faceless hearing. Thereafter, we have seen a paradigm shift in the thinking process of the government. What they are now trying to achieve is that let's do everything in a machine manner. Let's avoid the human interface. Let's do away with the concept of people meeting and discussing an issue. Instead, let machines talk. Let the written submissions, the written documents speak for themselves, rather than someone actually physically going there and explaining the concept. So we have seen a large number of sections in a very methodical manner getting amended. The first was, in fact, the definition of hearing itself is now amended under the Income Tax Act, 2/23C probably. The hearing is now is not hearing that we understand in the conventional terms. Hearing, by and large, what people understand by the word hearing is that someone speaks and the other person listens. That is known as hearing. Income Tax Act has a different definition of hearing. They say that hearing also includes submission of data, documents in the digital form. So that has now become the new hearing definition of hearing. And then if we look at the entire scheme, there are large number of amendments which are being carried out, wherein the concept of facelessness is now being brought into the sections. If we look at the existing scheme of the Act, you would find that right up to, I have not, the bill, Finance Bill 2021 is separately discussed, but even before Finance Bill 2021 came into existence, we had large number of amendments, and mind you, some of these amendments you will not find even in the latest Income Tax Act also. You can only find those amendments either in the website of the Income Tax Department or in the website of taxmen and such other service providers. You would find that 92 CA subsection 8, there is a reference to TPO, determination of ALP process. There also this section is there. ચાલશે, 2 નંબરની સ્લાઇડ કરશો ને તોય ચાલશે, વાંધો નથી. અહીંથી ફરશે. what we are seeing is, what we are seeing is that let's say 92 CA subsection 8 is now introduced. And what it says is that you can have a faceless mechanism for the purpose of TPO. Likewise, we have 144C subsection 14 capital B. So the reference to DRP is also now sought to be carried out in a faceless manner. So DRP mechanism is now getting faceless. We have 144 capital B where the entire scheme of faceless assessment scheme is now notified, and you will find the entire notification which was issued for the purpose of faceless scheme is now being incorporated by way of a statutory provision in the form of 144 capital B. Again, 144 capital B is not there in the latest act which is published. You will have to wait for some time, but it has already been incorporated into the website of the income tax. Then we have the provision of launching of prosecution. All of us are aware that before launch of the prosecution, Commissioner is required to issue a notice. SSA would be called upon to file a response under section 279. So that process is now also mechanized. That is also now getting faceless. We have 231, section 231, faceless collection and recovery of tax. So the collection is going to be faceless. Someone will by pressing some buttons, some amount will disappear from your bank account and would be credited to the bank account of the government. So recovery, collection, 142B, faceless inquiry and valuation. So all inquiries under section 142(1) pre and post amendment, as well as the valuation process, the entire process of valuation is now going to be faceless. We have 135A, faceless collection of information. So as against 131 and 133, we have 135A, where all information which is hitherto being collected in the physical form is now going to be collected in the faceless manner. We have section 130, where faceless jurisdiction of the income tax authorities. So you would not know which face you are dealing with. Chero Jovani Manai. Then you have 151A, faceless assessment of income escaping assessment. So reopening hitherto, in fact, in the e-assessment guidelines of 2019, reopening assessments were specifically kept outside the purview of e-assessment. So also search and survey cases where large number of material is seized. Now we have a mechanism where 151 capital A says that even reopening is going to be faceless. Then we have 293 capital D, which says that faceless approval and registration. So from next year onwards, all your section 12A, 12AB, 12AA, all those approvals as well as the registrations are going to be faceless. We have 157A, where rectification is going to be faceless. All amendments, 157A is sum total of 154, 155 and 156. All these three sections are now being redrafted in the form of section 157 capital A. So that is also going to be faceless. We have 264 capital A, which says that faceless revision of orders. So 263, 264, both, whether it is in favor of the SSC or against the SSC, both are going to be in the faceless manner. 264B will order giving effect to all appellate orders, 250, 254, 60, 62, 63, 64. So right up to Supreme Court, all appellate orders are going to be given effect to in the faceless manner. And on the top of all this, this was existing. Mind you, whatever that I have just discussed is all existing legal framework. Now we have the proposed amendment under Finance Bill 2021, wherein 245D11, the existing framework of Settlement Commission is now going to be abolished. In its place, we have the interim board, which is going to function like a settlement commission, but that too in a faceless manner. We have subsection 11 saying that that is also going to be faceless. We have 245 capital M capital A, which says that this dispute resolution panel also going to be faceless. We have 245 R9, wherein the smaller SSCs, the issues below 50 lakhs of rupees, a separate body is going to be created. That body is also going to function in a faceless manner. And the cherry on the cake, the last, the last straw on the camel's back is 255 subsection 7. 255 subsection 7 says that the entire functioning of the tribunal, income tax appellate tribunal, is again going to be faceless. Now, what is the object of this? As per the material which is available, in each and every section, the language is identical. I have generalized the language. Other than that, I have not taken any liberties in changing the content of the language of the various sections, which I have just summarized. The first object which is sought to be achieved is eliminating the interface between the AO, CIT appeal, ITAT and the SSCs in the course of proceedings to the extent technologically feasible. In other words, government does not trust its taxpayers, it does not trust its officers, people who are entrusted with the task of implementing and administering the Income Tax Act, because government does not want these two entities, namely the person who are representing the SSCs or the SSCs and the persons who are implementing the Income Tax Act. Interface? No, we do not want any interface. Maybe the object behind the same is noble, that we want to avoid corruption. But look, corruption is something which has to, it can only be avoided if there is a change in the mental setup. You devise a scheme which is supposed to be faceless, which is supposed to be interfaceless, and people will find ways to carry out corruption. So this is not going to help us in any manner. But in the process of curbing the corruption, we have devised systems which are draconian, which are something which we'll discuss shortly from now, which has created large number of problems for all entities, big, small, medium, all kinds of SSs. It has created lot of problem. The second part of this is that what they want to, the object behind all this amendment is that we want to optimizing utilization of the resources through economies of scale and functional specialization. Now, what does this mean? I, for one, fail to understand. Optimizing the utilization of the resources. Now, what kind of resources? The number of SSs are going to remain the same. The number of officers are also going to remain the same. And therefore, there is no gainsay in saying that there is going to be a resource utilization in the optimal manner. And then functional specialization. I again fail to understand what does it mean by functional specialization. Insofar as the appeals are concerned, take an example that there is one appeal which has large number of grounds. Some are dealing with cash credit, some are dealing with share capital addition, some are dealing with rejection of books, and some are dealing with international taxation. Would it mean that these grounds would be placed before the CITs who are specialized in each of these fields? So ground number 1 is given to some CIT appeal who is specialized in section 68 edition. Ground number 2 will be given to someone who is specializing in GP edition. Ground 3, transfer pricing, would be given to someone who is specialized in TP editions. This is not how the appeals are going to be decided. Then if the appeals are going to be decided by the same unit, by the same commissioner, then where is the question of functional specialization? Imagine the same situation for a tribunal. Tribunal, there the judges are there. Can we say that some judges are very intelligent, therefore they will handle only international taxation? Some are not so fortunate in the brain department, and therefore they will handle all this petty GP rejection and small disallowances matter. We cannot have such a segregation, and that is not feasible. And lastly, they say that we want to introduce dynamic jurisdiction. Now, what is the meaning of dynamic jurisdiction? Dynamic, if we take the dictionary meaning of dynamic, dynamic is something which is constantly changing. Now, do we want a jurisdiction which is constantly changing? Again, it's going to be difficult, because the jurisdiction term is now going to be redefined. Imagine a situation where SSC is sitting in Gujarat, filing the return through the online portal, return being given to someone in Chennai for the purpose of processing. Which law is applicable to that? Whether the officer sitting in Chennai will apply Chennai High Court as the jurisdictional High Court, or the Gujarat High Court as the jurisdictional High Court. And in case if the Chennai assessing officer does not follow the jurisdictional High Court, namely Gujarat judgment, then can Gujarat High Court issue a writ of mandamus whereby can he direct the officer sitting in Chennai to act according to the ruling of the Gujarat High Court, when certainly the territorial jurisdiction does not cover that. That gentleman sitting in Chennai is governed by the Madras High Court. So these are all interesting issues which are going to crop up, the way in which these implementations are happening. It would have been better had the government waited for some more time, because we are in 2019, we just started experimenting with faceless assessment. In 20, we started with the Commissioner Appeals faceless appellate mechanism. Probably tribunal could have waited for a couple of more years before jumping into that bandwagon, because today what is happening is we file the return in electronic form, your assessment is done in a faceless manner, your Commissioner Appeal decides your matter in a faceless manner, tribunal, after the bill becomes the act, is going to decide your matter in a faceless manner. Your question of fact is going to be now decided in a faceless manner, because before the High Court, what we can take is only the question, substantial question of law. So in case if there are factual discrepancies, if there are facts which are required to be determined, how do we do that? How do we make our representation before an authority who is actually there to hear our arguments? None. Answer is none, because ultimately everything is going to be faceless. Life is going to be very difficult, and because of that, let us look at the brighter side of that difficult life. The brighter side is that your drafting skills are going to be of paramount importance. The way in which you argue the matter, you need to develop your skills of writing in an identical manner. You have to somehow educate yourself and prepare yourself for putting everything in paper, so that the person who is reading the document, the reader of the document, would get exactly the same meaning which you really want to convey to him. It is going to be a difficult task, and it will take some time before all of us get used to that system. Before we actually go there, let's hurriedly look at what is the system, because this system is also quite complicated. In fact, in India, the other day someone forwarded me this message on the WhatsApp કે અચાનક ક્યાંકથી એલિયન્સ ઉડીને વર્લ્ડમાં આવી ગયા, અને એલિયન્સની પેલી ફરતી રકાબી આવી ઉતરી, એમાંથી કંઈ કમ્પ્યુટરના સ્ક્રીન ખુલ્યા, અને બધા દેશ વિદેશના લોકોએ ટ્રાય કર્યું એ સ્ક્રીન પર જાત જાતના ફોર્મ્સ બધું ભરવાને કરવાને, કંઈ ના થયું. કોઈ ઇન્ડિયન આગળ આવ્યો એટલે કીધું મને ટ્રાય કરવા દો, હું હમણાં ભરી દઉં. એણે ધડાધડ બધા ફોર્મ ભરી નાખ્યા. એટલે એવરીવન વોઝ હેપી કે ભાઈ આ શું થયું, તે કઈ રીતના કર્યું, આ તું કોણ છે, શું કરે છે એમ. તો કે હું ટેક્સ પ્રેક્ટિશનર છું, અને જીએસટી અને ઇન્કમ ટેક્સના ફોર્મ ભરીને એવો એક્સપર્ટ થઈ ગયો છું કે કોઈ અજાણી લેંગ્વેજ કે અજાણી ભાષાની અંદર કંઈ બી આપો, હું બધું કરી શકું છું. બધા ખુશ થઈ ગયા. થોડી વાર થઈ, એ ભાઈ બીકોઝ હી ફિલ્ડ અપ ધોઝ ફોર્મ્સ, એ આગળ ગયા અને એલિયન જોડે કંઈ એમણે વાતો કરી. એમણે તરત ઓફિસ બોય પાસેથી ઇન્કમ ટેક્સ એક્ટ, જીએસટી એક્ટ અને થોડા ઘણા પેન ડ્રાઈવ્સ મંગાવ્યા, એલિયનને આપ્યા. અડધો કલાક પછી એલિયનની છત્રી પાછી જતી રહી. બધાએ પૂછ્યું કે ભાઈ આ થયું શું? તો કે મેં એમને સમજાવ્યું કે આ એક્ટ છે અને આમાં આ ફોર્મ્સ છે જે તમારે દર મહિને અહીંયા ભરવાના છે, રહેવું હોય તો આવજો, અધરવાઇઝ પાછા જતા રહેજો. એટલે એટલી બધી કોમ્પ્લિકેશન્સ છે આપણા અત્યારે અહીંયા આગળ બધા, અને એમાં વધારો થઈ ગયો. નહીં, હવે એમાં આ વધારો થઈ ગયો કે ફેસલેસ પ્રોસિજર અને કોમ્પ્લિકેશન્સ એવા કે અનલેસ યુ ગીવ એવરીથિંગ ઇન રાઇટિંગ યુ કાન્ટ સર્વાઈવ. અત્યાર સુધી શું હતું, એવો ક્વેરી કાઢે, આપણે જઈએ, ડોક્યુમેન્ટ્સ લઈ જઈએ, સાહેબને છેલ્લે કંઈ ના થાય તો હાથ જોડીએ કે સાહેબ આ કેસ કરવા જેવો નથી, આમાં ના કરશો. ઘણા બધા એવો છે એ માની જાય. કંઈ ના થાય તો છેલ્લે યુ કેન ઓલવેઝ એક્સપ્લેન ટુ હિમ દેટ સર ધીસ ઇઝ વોટ ઇઝ ફ્લોઈંગ ફ્રોમ ધીસ ડોક્યુમેન્ટ. Take an example of a simple land document. Look, in this part of India, we have the system of entering into Manakhat first. Manakhat is agreement to sell. Based on the agreement to sell, we enter into the final deed. Final deed is whether it is as per jantri rate, not as per circle rate. If it is as per Jantri rate, then the same amount of stamp duty is required to be paid. And thereafter, we can file appeal if at all we are not happy with the stamp levy, these, that. Again, non-agriculture persons cannot buy agricultural land. These are all settled laws in this part of India, and everybody understands them. Now take an example, your assessment is given to someone sitting in Lakshadweep. Now that person would never understand that this kind of deals are also possible. They would not understand that a non-agriculturist cannot buy an agricultural land. They would not know what is a banakhat, which is again in the vernacular language. You will have to do the translation of the entire banakhat. Large number of such clerical work will go up. Look, faceless, the summary of faceless proceedings is, because for us it is very necessary to understand the summary of faceless procedure before we go to the written submission part, because unless we understand as to what is it that is expected of us as an SSCs or SSCs representatives, we would not be in a position to satisfy the government. Look, in all this faceless procedure, be it the assessment procedure, be it the penalty procedure, be it the CIT appeal procedure, or be it the proposed ITAT procedure. Let's keep proposed ITAT procedure out of this, because for the time being that notification has not yet come. In fact, the bill is still not made into an act, and therefore we do not know what kind of procedure is going to be ultimately notified. But in all this, the common thread is that now, as we have seen, the government does not want Parliament to apply their mind while drafting the laws. You will find each and every new law which is now enacted. In fact, in 2020, 21, both, all those sections which I have taken you to, the direct message is that Parliament is too busy to draft all these things. Therefore, we want to delegate this power to the executives. So effectively, instead of Parliament, now we have CBDT, and some of the officers notified by CBDT are going to be drafting all these schemes. The law also says that once these drafts are out, they are notified as notifications, within a period of 6 months, we'll take it up in the Parliament and we'll convert that notification into the appropriate piece of legislation. Effectively, therefore, what the government is doing is that they don't want Parliament to now enact the laws. In fact, if I remember correctly, when I was studying the Constitution, the sole purpose of Parliament was they are known as lawmakers. They make the laws. And because we have a structure whereby there is a checks and balance, that Parliament will make the law, the executives will implement the law. Now, executives are making the laws and they are also implementing the laws. And they have, in fact, this is the product of executive making a law. They have, this faceless procedure is entirely made by executives and implemented also by executives. And therefore, you will find at some point in time that this is all one-sided. As a lawyer, if I have to draft an agreement, then I'll see to it that the agreement is tilted in favor of my clients. And the same way, the draftsmen who have drafted this have made sure that the entire procedure is tilted in favor of the revenue. There are certain things which is very easily available to the revenue, not available to us. Imagine a situation that there is a survey action or a search action at your premises. You are coerced into making some disclosure. રાતના 2, 2:30, 3 વાગે કીધું કે સાહેબ કરોડ રૂપિયા ડિસ્ક્લોઝ કરો તો અમે ઘરે જઈએ, અધરવાઇઝ અમે બેઠા છીએ. In order to get rid of the department, many a times SSC succumb to these pressures. And they declare, કરોડ રૂપિયા ડિસ્ક્લોઝ કરી દીધા. સ્ટેટમેન્ટ લખાવી દીધું, મેં સંપૂર્ણ હોશો હવાસમાં મારી રાજી ખુશી મરજીથી કરોડ રૂપિયા ડિસ્ક્લોઝ કર્યા છે, ટેક્સ હું ડ્યુ ડેટ પ્રમાણે ભરી આપીશ. મારે હવે વિથડ્રો કરવો છે, રિટ્રેક્ટ કરવું છે, because it was done under some force. How do I file that affidavit? That simple task of filing an affidavit, I can always execute the affidavit, no dispute on that score. How do I file? Unless that tab is given to me, that tab is generated, where do I upload? Because I do not know who my assessing officer is. I do not know who is the range officer who has this jurisdiction over me. And unless called upon, you don't have to speak. You are not given any right to upload anything on your own. Unless that notice is issued, the tab will open for 15 days. You can upload documents, whatever is required, or you forget about approaching the authorities ever. As against that, every assessment unit has a power of calling for information without any restrictions. They can always tell the regional center that we want this information. Regional center in turn will tell the national center. National center in turn will issue the notice upon the SSC, and SSCs will have to furnish those details on record. Take another situation where you want to cross-examine someone, or you want to raise an additional ground which you have not raised. During the course of the assessment proceedings, you realize that you have incurred certain expenditure which you ought to have claimed as a revenue expenditure. Now, that is not related to any of the controversies which is there in the body of the assessment order. This is a fresh claim which you want to raise before the assessing officer. Hitherto, the law was, as per the Goetze India's case, that you can't raise a fresh claim before the assessing officer. Nonetheless, you can file the letter raising this claim. Assessing officer might reject that claim, saying that you have not filed a revised return, therefore I will not entertain this. But based on this letter, at least before the appellate authority, you can plead that, sir, look, I raised this claim before the AO, he did not grant me this claim, now you allow me. Now, I don't find any mechanism whereby I can raise an additional claim. I am only called upon to answer the notices which are issued to me. In that notice, probably I can raise as one of the additional ground that though it does not concern any of the queries, nonetheless, I want to raise this additional fresh claim, and you kindly entertain that. So these are all one-sided mechanism, but the crux is that we have one national body, which is either national assessment body or national appellate body. Below that, we have regional bodies. Regional bodies, basically, they don't do anything. They are just for the sake of bifurcation. Below regional bodies, we have units, and below units, we have actual officers working under those units. They are either automatically assigned a particular assessment or a particular appeal, all based on some representation. The national body can, on a specific case-to-case basis, assign a particular case to particular officer. Once the scrutiny starts, he issues the notice under 142. You are called upon to place on record certain details. Those details, again, once you place on record, based on those details, authorities can call for more details. Now, all this communication is never happening between the SSC and the actual assessment unit. It's a triangle situation. It's a triangle, basically. The National Assessment Center is at the top. We have unit here as one of the angles of the triangle, and we have SSCs here as one of the angles of triangle. They never talk with each other. The SSCs and the unit, they don't talk with each other. They always talk through the center. Therefore, the whole idea behind this is that there is complete anonymity. There is no interface between the SSCs and the assessing authorities. Now, with this situation, everything is going to be in written mode. The importance of drafting is all the more important. Drafting is basically hitherto, drafting was a precursor to actual arguments of the matter. And therefore, drafting, though it was important, was always to be supplemented by the oral arguments. Now, drafting is the beginning point and drafting is the end point, because you are not going to get any opportunity of actually arguing the matter. Though I'm conscious that we have provisions under schemes whereby you can ask for a specific hearing insofar as the appeal scheme is concerned. In a given case, if the authorities feel that yes, this case needs physical hearing, they can, in a case-to-case basis, consider the request. But as a rule, not as an exception, the rule is that the issues are now going to be decided based on your written submissions. And therefore, we'll have to look at some of the basic principles, because those basic principles would remain the same. Your rights, your obligations, your duties, everything will remain the same. Only difference is that as against the opportunity to set right your lacuna in the written submissions by way of speaking, by way of arguing the matter, now you will not get any such opportunity to improve upon your written submissions. The first and the basic principles of natural justice which are required to be remembered. Look, these are all the basic principles. Hopefully, they are still there in the statute book, because the way in which statute books are changing, we do not know whether this principle of natural justice also, for how long it is going to stay in the statute book. But today, as we know the act, and as the act is implemented by the courts of law, the principle of natural justice is there. And principle of natural justice is, what is principle of natural justice? It says that odi altum partem. Now, what is odi altum partem is that someone who is going to be penalized, someone who is going to be prosecuted, should not be prosecuted or penalized without giving him opportunity of hearing. Hearing, as I stated earlier, is now in the form of a written submission. So, principles of natural justice are there. We have, let's look at the principles of natural justice in a slightly detailed manner. Look, principles of natural justice, what does it mean? Principles of natural justice is that whatever evidences, whatever material which is available with the assessing officer is required to be shared with the assessees. So, supposing your case is selected in the faceless assessment, and the assessing officer has some material whereby he says that you have done transactions with a Bombay-based party. That party is now held to be a fictitious party, and that party has issued certain checks in your favor. We find that you have received a payment of rupees 1 crore from that party, and therefore we want to add that money, 1 crore rupee, as your income. Now, we do not know what is the name of that party. We do not know what is the check that the assessing officer is talking about. On what basis it is now held that that party has been held to be a bogus party. That is where the principle of natural justice comes into play. Natural justice says that you can demand all this material from the assessing authority. So, every evidence, every material, namely the statement of that party, the bank account of that party, the exact check number of that party, the person who has made this statement, his name, opportunity of examining and cross-examining that person, all these are forming part of the natural justice. And maybe the proceedings are in writing, but nonetheless, you can always demand all this material. The moment there is a show cause asking you to give explanation on this amount of 1 crore allegedly you have transacted with that party, the next thing is you write a letter calling for all this information. And as a matter of right, as it is your inherent right to get all this information. Show cause, hitherto in fact, the law was very, very clear. However, there was no specific provision under the scheme of the Act whereby show cause was compulsory. And many a times you would find that authorities would not issue the show cause before making the final assessment. Now we have the provision, namely section 144 capital B, subclause 16, subclause small b, saying that before any final edition, a show cause is must. It's a sine qua non. It is without show cause, you can't make the final edition. Because all of us are aware that once the final show cause is issued, and once I file my reply, the draft assessment order is prepared as per the scheme. And once that draft, whether it is assessment order or appellate order, is prepared, then that draft is sent to the review unit. Review unit will, based on the risk criteria decided by the CBDT, will decide whether all the additions are proper, all the grounds are properly dealt with, if it is assessment or appellate proceedings. And based on that, either the case is taken for review or the order is finalized on the basis of the draft. So, show cause notice, yes, we are now fortunate, at least this is the brighter side of the entire mechanism, that will be issued final show cause notice before any variation is made to our returned income. We have a right of rebuttal. So, whenever any material is used against us, we have a right of either filing our response to that, our explanation, and right of rebuttal, which is intrinsic part of natural justice. Any third party evidence, be it statement of entry provider or any material, any seized material or any bank account, leisure account, all this, everything, third party evidences are required to be shared with the assessing, with the assessee. full access to the assessment file. Again, it is going to be access in the digital form. Examination and cross-examination of the witnesses, and then we have affidavits. If at all any affidavit is used by the assessing authority, because nowadays what is happening is that assessing officers have also become smarter. So what they do is they try to take the affidavits of all these tainted parties. So those parties who have made disclosure before the authorities, either penny stock operators, shell company operators, or the persons who are giving bogus accommodation entries, all those persons have started executing affidavits in favor of the revenue authority, saying that the statement is correct, whatever information that they have given is correct, true to his belief and information. And in case if such an affidavit is there, the only way in which SSE can get out of that affidavit is ask for the cross-examination of the deponent. Because the law is again well settled that if you do not challenge the contents of the affidavit, then ultimately at a later stage you can't challenge it. Therefore, principle of natural justice demands that you ask for the cross-examination of that person based on his affidavit. The burden of proof is again, it keeps on shifting. Initial burden is always that of the party which is making such a claim. So if you are an SSE and if you claim a particular expenditure as an allowable expenditure, the burden is upon you to initially satisfy the authorities. Once you satisfy the assessing authority based on your submissions, etc., then the assessing authority has to either prove that the submissions which are given are not correct or they are false. Only if he proves that this submission which is given, the material which is given, the evidences which you have adduced on record are factually incorrect or they are incomplete, he can't again reverse the burden and ask you to submit more. So in case if he is happy with the evidences, the matter rests there. In case if he is not happy with the evidences, he would ask you that, sir, you have given the bank statement. In that one entry is there. Kindly explain that entry. From where have you received that credit? If that question is put to you, then you are required to answer. And then once again, the burden shifts on the SSE. It becomes very more important for the simple reason that in the physical assessment, the assessing officer will tell you that nahi bhaiya ye barabar nahi hai, you get me some more information on these creditors, you get me some more data on this particular donor. Now this is going to happen by way of communication, digital communication, email, or on the portal you will be again issued a notice. So develop the habit of reading the entire notice at least twice. If you are not very confident, take help of someone who is also working in your office. Ask him to also read that notice once again. Because every full stop, every comma will have a different connotation. So if you misinterpret the particular sentence and if you give data which is otherwise not required, then you are in a larger problem. Or if you miss out on furnishing some data because you have read it hurriedly in a cursory glance and you are satisfied that, oh, he asked for the name and address. Next line you haven't read that he also wants the confirmation. You immediately draft a letter, give names and addresses, and you forget about the confirmation. Physically, when you go to the assessing officer, he'll immediately tell you that, sir, where are the confirmations? Then you will say, okay, all right, by next, keep it next week, I'll come with the confirmation. Here, it is not going to happen. At least once or twice, they are going to issue the notices. Thereafter, the portal is going to close and your assessment is going to be done based on whatever that you have uploaded. Evidences and material, both are different. Both are required to be given during the assessment proceedings. Evidences means oral written statements and documents, whereas material also includes explanation, submissions, contention, claims, detailed information, statements, affidavit, books of accounts and records. So whatever is that is required. And mind you, this is a two-way traffic. Evidences and material are required for the purpose of satisfying the assessing authority. At the same time, if the assessing authority relies on evidences and material, then you have every right of asking for those details. Once you ask for those details, you can give your explanation based on those details. Unless that two-way traffic is taking place, you can't, frankly, satisfy the assessing authority. Look, this is what I indicated in the earlier part of my discussion, that in case if survey search statements are there, how do I file the retraction statement, retraction affidavit? That window is now no more available. You can, in a given case, give the same affidavit to the investigation wing who is carrying out the search or survey. But the experience over a period of time has shown that such a step is never welcomed by the investigation wing, and they by and large try to create more problems for the SSCs who have filed such an affidavit. Fresh claim, I also covered this, that whenever you want to raise a fresh claim, Goetze India apart, how do I do it without my assessment proceedings actually commencing? Supposing my assessment proceeding is not at all commencing, then I can't file any additional claim unless I file a revised return of income within the permissible time limit. And ultimately, if no assessment, no fresh claim, even during the course of the assessment also, as and when that portal opens for the purpose of acceptance of the reply, I have to submit the reply. Someone who is already dead, someone who has died, and that SSC's assessment is now happening, what is the law on the issue? Because that law would still continue to govern even as of today also. Even under the Faceless scheme also, that law is not going to change. And what is that law? Law is that in case if the SSC passes away, if he is dead, then the legal heirs, as per section 159, would step into the shoes of the SSC. Now, there are certain situations where if the SSC dies well before the due date of filing of return, then obviously return for that period is required to be uploaded by the legal heir. Then there is no issue because that legal heir is already substituted. After filing the return of income, but before 143(2) notice is issued, if the SSC dies, then the moment you receive 143(2) notice, you are under an obligation to intimate the revenue authorities, the department, that the person is no more. If the time is available with the authorities, they would issue a fresh notice under 143(2). If that time is not available, then that statutory notice would not be held to be a valid notice, decided now by Supreme Court in the case of Maruti Suzuki. And therefore, the entire assessment is now cost and set aside. It will not be a valid assessment. However, if someone dies in between after receiving 143(2) and after reading it, he suffers a heart attack and he dies, because 143(2) notices are, at times very scary. He reads it and he dies. So he has already technically received the notice. That notice is received by him, but before final order could be framed, he is no more. Then in that scenario, 143(2) notice is valid. However, the final assessment order is required to be done in the name of the legal heir. And unless that legal heir steps into the shoes of the SSC, that order, if it is passed in the name of the dead person, is going to be held as an invalid order. And after 143(3) order, after receiving 156 demand notice, if someone suffers heart attack and dies, then he is not there in the picture at all. However, two things are required to be done. One thing is the demand notice which is issued by the assessing authority. If it is more than the estate of that person who has passed away, the dead person, the deceased person, then you are required to intimate to the assessing authority that his dues are 1 crore, whereas his estate is only of 10 lakhs of rupees, and therefore you kindly keep that on record. However, the appeals, etc., will have to be filed by the legal heir. Additional deduction and exemption, if you want to claim that without filing the necessary reports along with the return of income, then what is the situation? Situation is, even after we have certain amendments in the statute, wherein the view that is taken is that unless you file your return of income in time and along with those audit reports, you can't claim the deduction and or exemptions. Courts have taken the view that those are a procedural report and you can file those reports. Supposing you have to claim deduction under section 10AA. Now, you have not filed the auditor's report along with 10AA. You have forgotten to upload that audit report. Suddenly, you realize at a later stage during the course of the assessment proceedings, you can certainly upload that audit report as and when the window opens even if the actual audit report uploading window does not open, you can file that as an annexure along with your reply and place it on record, and probably at a later stage you can plead before the authorities that such a document may kindly be taken on record. Look, now comes the rights of the SSE. Rights of the SSEs are, as I have discussed earlier, you have right to ask for each and every material. Mind you, these material are restricted only to the show causes which are issued by the department. If there is no show cause on a particular transaction, then you can't ask for the material from the department, because then that window will not be available, and then the law is that unless the assessing authority uses some material against you, they are not under any obligation to share that material. Supposing therefore, in a given case, some of your suppliers, some of the persons from whom you have purchased the material, they are directly issued notice under 133(6), and they have given a positive reply for the year under consideration, and therefore assessing authority has closed the file. However, in the next year, when the assessments are framed, those parties did not reply, did not respond, and therefore you wanted the material in year number 1 to be kept in your file, so that at a later stage you know that he has shut down his business and he has now disappeared. Those confirmations can come to your rescue that this party was genuine when we entered into the transaction. In order to establish that correspondence with the assessing authority, you can't ask. However, in the physical form, that probably is possible, because you can go and approach the assessing officer and get the copies. However, under the faceless mechanism, such a thing is not possible. Then, before the authorities, before the assessing authority, what is required to be done is, look, there are people who have the habit of submitting case laws before the authority. I have been time and again telling the people, in my almost all my presentation, I have been telling that at the assessment stage, don't go beyond the facts, because law is, no one is going to look into the law, A, and B, in case if you rely on some judgments at the before the assessing authority, and by God forbid, such judgment is reversed by the appellate court by the time your matter is taken up by the tribunal or higher appellate authority, then you are in for a larger trouble, because you yourself have said that my case is covered by this judgment. Now that judgment is no more good law, because that is now reversed. Therefore, don't be tempted in citing case laws before the authorities. Give proper facts along with all necessary evidences in support of those facts. I think if you do that before the assessment authority, before the faceless authorities, that also would be sufficient compliance. You don't need to cite any case laws unless you are very sure that this case law is directly on the issue, it is not going to be reversed, or it is that of the Supreme Court and the law is well settled. Don't venture into citing the case laws, because it has more disadvantage than advantages. Alternate contentions, always feel free to raise the alternate contentions. Nowadays, we have this movement which is going on, that you compare the GST turnover along with income tax turnover. If there is any deficit in the income tax turnover, straightaway addition would be made. We have now 271AA saying that in case of such a discrepancy, the penalty would be of the equal amount of such a discrepancy. 100% of the discrepancy is now going to be levied as by way of penalty under section 271AA. What is the alternate contention? That in case if there is a discrepancy in the turnover figure, then what you can say is that, sir, under the Income Tax Act, my tax is only on the profit, on the income, and not on the gross turnover. So therefore, in case if there is a difference between the turnover figure, and in case if you are inclined to add that turnover, then kindly add only the profit element of that turnover and not the entire turnover. So that is going to be my alternate contention. First contention is obviously that there is a reconciliation statement. I have an explanation. There is no difference between these two turnover figures. But then the alternate contention is that in case if you are not satisfied with that, then kindly add only the net profit which is embedded into that undisclosed turnover. Many a times people have this apprehension that the moment we take an alternate contention, there is a dimmed tacit consent to making of the addition. The law is well settled on that issue, that in case if you write very categorically that without prejudice to my earlier submission, alternatively and hypothetically, if you are going to add the turnover, you can only add the net profit which is there in the turnover. If you write in such a way, maybe some variation here and there, then no courts will take an adverse view that you have accepted that to be your addition in your hand. That is not going to happen, and therefore feel free to raise all kinds of alternate contentions. If you have more than one contention, supposing in this given case, you may say that, sir, kindly add GP. Then if not GP, kindly add NP. If you go on submitting like this, or supposing you may say that, sir, in these two turnover figures, so much of turnover has a direct explanation because those were goods returned, and because of the time difference between the filing of GST returns and income tax returns, the returns are reflected in the later part of the returns of next period, and therefore you don't make any addition, at least in so far as that part of the turnover is concerned. So you may say that, sir, out of 100, 50 is because of this reconciliation difference, therefore you don't make any addition on 50. Remaining 50, this is my explanation. If I fail on that explanation, profit only on 50. If I again fail on that explanation, then profit on entire 100, and that too of NP or GP. So this is the way in which one can raise additional alternate contentions. Look, you should not concede at the show cause notice stage. Nowadays, I've been advising all my clients that now the law is going to be extremely difficult, because faceless stages and thereafter going straight to the High Court on a pure question of law. Therefore, don't, in case if you are not very confident about a particular adjustment, don't make such adjustment in the return of income. Don't claim anything where there is some doubt. Don't hesitate in offering an income. In other words, offer the income where there is a slightest amount of doubt. So don't play with the Income Tax Act. Whatever is due, show it in the return of income. Supposing there is some query which has now come from the department, and if you believe that this is the item where my explanation is not going to stand, you can always concede. After the assessment, in fact, we have a mechanism whereby 270AA is there, section 270AA is there, whereby after the assessment order is received. And if you believe that these are items where I don't have any case, I can straightway pay the necessary taxes along with interest on that particular disallowance with an undertaking before the AO that I am not going to take these particular issues or this order in any further appeal. And therefore, I concede. And the advantage would be that there is not going to be any penalty or prosecution against that acceptance. However, this is available only insofar as misreporting is concerned. In the language of 270 capital A, there are two kinds of adjustments. One is misreporting, another is underreporting. Misreporting is mismatch. Underreporting is a deliberate attempt on the part of the assessee in concealing certain things. So 270AA is, if at all you are confident 270AA is coming to your rescue, you can concede. But other than that, the disadvantage would be that the moment there is a show cause and thereafter you concede, the revenue authority will say that this is a declaration after the detection. And once the declaration after the detection is caught by the revenue authorities, they would say that, sir, pakadai gaya, etle kabul karo છો ગુનો, બાકી તમે ના કર્યો હોત. And therefore, they'll nonetheless, without even ignoring your conceding position, they will levy the penalty. So therefore, idea is not to concede. You have to place on record all relevant documentary evidences before the assessing officer. Don't hold back on anything. Unless, of course, you believe that if you place on record certain documents, those documents are going to be held against you. And because those documents are going to be held against you, there is going to be a consequential proceedings which are yet not time barred, and therefore you choose not to place those documentary evidences on record. Supposing in a case of 222E, in year number 4, assessing authority calls upon you to justify 222E transaction. You realize that there is a common director, and in case if you take a stand that the recipient of the money is not the shareholder, then the common director, who is the shareholder, is going to be now revisited. He would be called upon to pay taxes on this deemed dividend. So many a times people don't give that information because they believe that by giving that information that the director has received this money, there may be a reopening in the case of the director. Instead, company is in any case already there in the litigation. Let company face the music, and at a later stage, if the court permits, we will place on record all these documentary evidences. But in case if you believe that these documents are otherwise necessary, they are otherwise required to be placed on record, place them on record. Bank statement, if at all authorities have called upon to place on record the bank statement, you place on record the bank statement. Unless you believe that authorities have caught you only on one credit transaction and there are large number of other such credit transactions where you have no explanation. In that scenario, probably maybe a selective furnishing of information is many a times resorted to, but otherwise place all documents which are available with you on record, because now the game is going to be played in a different way. Hitherto, commissioners were very liberal in entertaining the additional evidences. They would immediately say that, "Acha, remand report mangwa lete hai, aap de do compilation bana ke." Now we do not know how the person who is going to decide your faceless appeal is going to react to this. Unless you have compelling reasons in satisfying 46A criteria, additional evidences would not be taken very willingly and very promptly by the authorities. 263 and 147, how the same can be avoided, how those actions can be prevented. Give a proper reply to show cause, deal with each and every argument of the show cause, and place on record all material facts which are necessary. Once we do that, then probably we can avoid 147 or 263, because 147 again, in case if it is beyond 4 years, we can say that everything was placed on record, there was no failure on the part of the SSE in disclosing fully and truly all material facts. Or you can plead that there was a change of opinion, though I placed every document available with me on record, he rightly or wrongly accepted that, and now it is not open to him to change that opinion. Same is the case with 263 also. Once you place on record all documents, then you can say that, sir, assessing officer has already applied his mind, he has processed this issue, and out of the two possible views, he has adopted one of the views, and therefore, as a revisional authority, you can't say that his view is wrong merely because you happen to have a different view. Then comes the post-assessment precautions. What are the post-assessment precautions? You read the whole order, because now it is again more important, because this is for the first time in the faceless proceedings, you will come to know that this is what has been held by the assessing authority. So the first opportunity for you to test the effectiveness of your written submissions is by reading the assessment order. You may be very clear in your mind that, sir, I want to present the case in this particular manner. But when you actually write down those things, it may not carry the same meaning. It may carry a different meaning than what you want to convey. And in case if there is any variation between what you really want to convey and what is actually conveyed, this is the opportunity where you will come to know for the first time by reading the assessment order that, અરે આમાં તો આપણે આવી ડિટેલ્સ આપેલી હતી, આ તો સમજો જ નથી. એટલે એ નથી સમજો એનું કેવળ જ્ઞાન આપણને ઓર્ડર વાંચવાથી થશે, અને એના જે રેમેડિયલ એક્શન આગળ લેવાના હશે તે that we can take. So you read the whole order. Don't leave anything to chance. People have the tendency of reading only the last page. That આટલી addition થઈ છે. But my advice is, in this faceless era, read the whole order, because there could be some hidden observations by the assessing officer which may not hurt you in this matter or in this year. It may hurt you in the later years or in some of the earlier years. Demand computation, of course, all of us are going to check that. all variation to return of income, you prepare a table whereby return income, assessed income, variations, and those variations must tally with the individual additions or disallowances. Any factual inaccuracies, anything which you find that not properly recorded or recorded in such a way which was not what you want them to record, immediately file a 154 pointing out that these are the errors and these are the rectifications which I am requesting. In case if rectification is not possible, or if you believe that that is not going to solve any purpose, then such inaccuracies or such inconsistencies they are required to be demonstrated in statement of facts when you file the appeal. So when you file the appeal, you prepare SOF, statement of facts, and in those SOF, you point out that, sir, these are the problems with your assessment order. This is what I submitted. This is what is understood, and this is where the problem lies. Look, these are all new precautions which are very specific to the faceless era, that you need to take the entire backup of the data. Whatever that you upload, you keep in two formats. One is in the soft form in your computer or in whatever safe place, either in the pen drive, client-wise pen drive, hard disk, cloud, wherever you feel safe, you take backup of that data. And second is take one hard copy. Always have the habit of take one printout. I understand that printing is frowned upon. It is not environmental friendly. But in case if you believe that something which is very important, take the printout of those documents. Keep one hard copy in your file. All the acknowledgements which are very, very crucial, because we have come across cases where on day one it is shown that yes, your email or your reply is received. After a week, when you again log in, that entry suddenly disappears, and therefore you have no proof of claiming that, sir, I uploaded that, I checked the website was showing that yes, my response is received. Now suddenly the website is silent, it says that your response is not received. So take the printout of the screenshot, or if you have some mechanism whereby you can save the screenshot so that you can at least plead before the authorities that you have complied with the notices. Backup, never ever rely on government portals, because we have filed high court petitions for the purpose of retrieving those backups. Look, before appeal, I'll come back to appeal in a short while from now, if there are ultimately the time permits. Now the written submissions. This is very, very crucial, because written submissions would help you at both the places. These are written submissions which are can be filed before the assessing authority or can be filed before the appellate authorities. Look, written submissions are crucial for the simple reason that they are going to argue your case before the authorities. That is where you are going to plead your case. And in your absence, your written submissions would speak for themselves. My suggestion is that in case before the assessing authority, if you are filing the final written submissions after the final show cause is issued, or before the appellate authority, you are filing written submissions, first broadly note down what are the issues which you want to cover in your written submissions. In a rough piece of paper, or prepare a small bullet point, what all issues you want to cover in the written submissions. Based on that, if it is the assessment proceedings and the final show cause is issued, you compile the data which you have already given to the assessing authority. Before the appellate authority, you already know what is placed on record, and that compilation is always available with you. So once you formulate what is going to be the written submissions, you straightway go to the paper book. Prepare the paper book first and then only prepare the written submissions. The advantage would be that once you put everything in the paper book, before the assessing authority, whatever that you have submitted so far can be placed in the form of a paper book. Before the commissioner appeals, before the appellate authority, whatever has been placed before the AO can be compiled by way of a paper book. Once you prepare the paper book, you will be in a position to know that what all documents are already available on record. Immediately, you know that I want to raise ABC issues. However, for ground C, I don't have any material in the paper book. Therefore, I need some additional evidences, some additional documents, some other material. So you can either prepare those documents and upload them separately before the assessing authority, or you can prepare a compilation of additional evidences before the appellate authority. Once you prepare the paper book, duly certified, continuously paginated, in an index format, you have page number of each and every document. And that becomes your reference point. So when you prepare the written submission, you can give the reference of the page number, exact page number of the paper book. So you can say, while referring to the GP chart, let's say you say that I have placed on record the GP chart, wherein last 3 years GP is there. On page number 55 of the paper book, paragraph 5, GP chart is there. In line number 3, GP for immediately preceding previous year is so and so, which is less than the GP for the year under consideration, and therefore my GP is better. Therefore, there is no reason to reject my books of accounts. Unless you do this, you have to cultivate this habit, because otherwise, even if you make a submission that my GP as against last year is better and therefore no adjustment is required. Now, who is going to verify whether your GP is better, bad, worse? Where are those GP figures? GP is there in page 55 of the paper book. How have you linked those two figures? Unless you do that, or you keep on reproducing GP figure every time you write the submission, that is another way of doing this. But then again, those GP figures will have no material to support them, whereas paper book has all the material. Immediately after the GP chart, you can annex the profit loss account for 3 years, and authority can find out that whether these GP figures are correct or no. So therefore, first prepare the paper book, thereafter prepare the submissions. Now submissions are going to be prepared based on the facts and facts alone. First, present the facts as they have been presented before the authority, lower authorities. Look, I have seen that people have this tendency of answering the queries, giving vague replies. પેલી જોક જેવું છે ને કે કોઈ એક ટ્રેન ઊભી રહી અને સવારના ભાઈએ બારીમાંથી પૂછ્યું કે ભાઈ આ કયું સ્ટેશન છે, એટલે કોઈએ જવાબ આપ્યો કે રેલવે સ્ટેશન. એટલે look, answer is technically 100% perfect, but it is not carrying the matter any further, because I also know that this is railway station, but I wanted a specific answer. So when pleading before the authorities, stay away from answering these kind of questions. પેલા ટેલિફોન પર પૂછે ને કે ક્યાંથી બોલો છો, તો કે મોઢેથી. હવે એ આન્સર ટેકનિકલી કરેક્ટ હોય, પણ એનો પર્પસ કશો સર્વ ના થાય. So when you present the facts, we do not want confusing facts. We want only the crisp facts which are dealing with the issue. We do not want facts which are confusing. I remember during early 2000, I came across one statement of facts prepared by some tax consultant or some chartered accountant, I don't remember exactly. Detailed statement of facts. It was a search case and statement of facts running into more than 60-70 pages. And it was like a novel that at 11:30 the doorbell rang and tax authorities barged into my house. At 1:30 they asked my family members to prepare bhajiyas. And at 4:40, incidentally, at 4:40, one of the family members who was pregnant at that time, she started suffering the pain, and therefore she was asked, the authorities were asked that whether we can take that female to the maternity hospital or no, and authorities reluctantly granted the permission. So all these facts are completely unnecessary. We do not want to know whether the chai, bhajia, 11:30 આવ્યા, કોને કેટલી delivery થઈ. We are not concerned with that. Look, we are concerned with the hard facts, and facts are that during the course of the search, the jewelry worth 1 crore rupees was found from the cupboard. That was all that was required from that. Therefore, we are not writing a story. And believe me, the size of the submission is again going to decide your matter. Smaller, the better. The moment you stretch it into a big volume, a big written submission, maybe you can charge more to your client based on number of pages, but it is not going to help your matter. If you can prepare the submission in 3 pages, do not go to the 4th one. Take all necessary facts, all relevant sections, that this edition, ground number 1, these are the facts, this is the section which is required to be interpreted. Based on this, these are my arguments A, B, C, D, and based on this, these are the case laws on which I rely. Case laws are 1, 2, 3, 4. All these case laws, paragraph number 5 in case law 1, paragraph 6 in case law 2, and so on and so forth. I make a very small, concise, crisp, and to the point written submission. Once I do that, then probably I can retain the attention of the reader. The moment I convert that submission into a huge long essay, then probably I am losing the attention of the reader. And mind you, if I lose the attention of the reader, reader is not a loser, I am the loser. And therefore, I need to make it as small, as concise as possible. In a given case, you may argue that, sir, it is not possible to prepare 3-4 page submission in each and every case. I understand. In that case, what you can do is, you prepare a detailed submission and give executive summary in the front. Make detailed submission, give a small synopsis, small summary in the front, whereby in the bullet format, you point out that these are the arguments, you find the detailed arguments on pages so and so to so and so. These are my arguments, you find detailed arguments on pages so and so to so and so. So that is how you can, cater to both the categories of reader. Someone who is interested in reading the details can read the detailed submission. Someone who is not interested in reading the details can go through the summary. Like, we in the morning, we read the newspaper. Most of us read the headlines first. In case if you are interested and if the time permits and if there is some tea left in the cup, then we'll read the entire item. Otherwise, we'll only scan through the headlines. This is precisely going to happen when the assessing authority is going to take up your case. You want to give the catchy head notes, catchy headline. And once he catches the attention, he will read the entire content. In a given case, if you don't want him to look into that, you have to give a boring headline also. Because many a times what we do is, we try to, let's say, in a given case, we know that the notice is completely illegal because the notice is served on someone who is not authorized to receive the notice. 292BB says that in case of any dispute as regards the service, I have to take the objection before the assessing authority. Unless I take that objection, I can't take it before the appellate authority. Nonetheless, I don't want to make it so apparent that he issues me a fresh notice and serves it upon the authorized person. So while writing pages, I incorporate those 2 lines somewhere in the middle, that your notice is even otherwise without jurisdiction because it has been served on someone who is not authorized to receive the notice. So that way I submit, but at the same time, I don't attract attention to that submission. Again, it all depends on the skill of the draftsman and the way in which he wants to present his case. But nonetheless, you use good language, because language is going to speak for itself in your absence, and that is going to be your ambassador. Your language is your ambassador. Don't make any allegation. In case if you are arguing before the appellate authority, don't say that assessing officer dobo હતો. ભલે ડોબો હોય, પણ એ કહેવાય નહીં. એટલે એમ જ કહેવાય કે learned assessing officer. Maybe you don't agree with that learned part, but nonetheless, you don't make allegations. Alternative contentions, pleas, arguments, everything is required to be mentioned. Last bullet is very important. Look, anticipation is the mother of writing good submissions. Unless I anticipate in advance that what the other side is going to argue or what can go against me in this particular fact, only those persons can write a good written submission. Otherwise, it is going to be a monologue. I write submission only from my point of view. But then I'll have to think from the point of view of the text assessing officer. An assessing officer's point of view, supposing you come up with 2 arguments, that sir, in a given case, revenue authorities can argue like this, they can also argue like this. You incorporate both those, that in case if the argument is this, then my answer is this.
And in case if the argument is this, or you rely on this case laws, then that has already been distinguished in the later judgment of Gujarat High Court or Supreme Court or any such authority. So the anticipation, good anticipation of the opponent's argument can give you an edge in preparing the written submission. Then comes the facts. I already discussed. Yes, paragraph numbering and exhibit numbering is also very, very important, because unless you give the paragraph numbers and reference exhibit numbers, you can't probably refer to those things at a later stage before again the higher authorities. So be very careful in giving the paragraph numbers and in giving the continuous page number, in giving the exhibits the sequential number. Don't write a letter every time, a letter with exhibit number 1, exhibit number 2. Then every time I want to refer to that exhibit, I'll have to refer to the letter also. That exhibit 1 to letter dated so and so, exhibit 1 to letter dated so and so. Instead, in case if you are facing the assessment proceedings, give the continuous exhibit numbers irrespective of the letters, so that you can keep track that I've placed on record 13 exhibits over a period of 4 months. Same way before appellate authority, in case you already have the entire material available with you, therefore you can give exhibit numbers the way in which you want to give. Avoid the temptation of citing large number of case laws. Even if you have, let's say, 30 case laws on a particular issue, we do not want all those 30 case laws. You are learned, well read, we all know that. But authorities, they are not there to appreciate your learnedness. They are not there to appreciate your knowledge. They are there to decide the issue. So unless you give most relevant 1, 2 or 3 case laws, citing large number of case laws is not going to serve any purpose. And at a later stage, if you think of filing a reply or a rectification saying that case laws number so and so, so and so, so and so have not been considered at all, and therefore it's a mistake apparent from record, that only will increase your work burden and it is not going to get you any relief. So in case if you find that there are large number of cases directly dealing with the issue, then also avoid citing them. Cite only 1, 2 or 3 judgments on a particular issue. I'm not saying that in the entire written submission you cite only 3 case laws. On a particular issue, cite not more than 3 case laws which are directly on the issue, with paragraph numbers duly marked. In case if it is soft copy, highlight those paragraphs and make a reference of those paragraphs in your written submission. Digital signature, again, I'm sure that all of you are more knowledgeable than me in so far as digital signature is concerned. So you, wherever you need digital signature to authenticate a document, put those signatures. In case if you find that the scanner has scanned the document in such a way that it is not very legible, get it typed at your end so that the contents are not lost in the process. In case if you really want the authorities to read them, then give the type copies. In case if you believe that the scan copy is not proper. At this stage, let me deviate. In this era of faceless proceedings, invest heavily into good internet connection, invest heavily into good computer infrastructure, buy all the licensed softwares, including Windows, including whatever other software that you use, more particularly the Adobe Acrobat that we use by and large to generate PDFs. Invest in good camera, high definition, good camera, and most importantly, invest in good microphone. I have seen people not investing in microphone. Recently, I was appearing before Supreme Court and the gentleman was arguing, his voice was completely cracking. He was not at all audible because of the poor quality of microphone. Probably it is here where China is really creating problem for us, because all Chinese made microphones, they pick up only few words out of the entire sentence. In fact, fortunately for that gentleman, he was saved very closely, because what he wanted to convey was that usually I agree with the arguments of my learned friend. However, in this case, I am not agreeable. What was heard by the entire, those who were live on the system was, I am agreeable with my learned friend. He said that was with a proviso that usually I am in agreement with my learned friend. However, this time I am not in agreement. What was heard by all of us was he is in agreement with his learned friend, and probably court would have dismissed his matter But he was fortunate enough to have survived those hiccups. But then invest in good microphone, because in case if you get an opportunity to present your case, physical or this new physical is new electronic arguments. So in case if you are allowed to argue the matter before the authorities, then you need all this internet connection, cameras and all other proper hardware support. Also prepare a desk where everything is handy, your books, your case laws, your submissions, everything is well within your reach. In case if you don't have such a setup, then probably you will find it extremely difficult to argue the matters before the cameras, in case if you are given the chance. Then comes the aspect of, yes, every appellate forum, every authority has different set of rules. And you must go through the rules. Like tribunal has different set of rules when it comes to submitting the documents, whether it is in the proposed e-format or physical format. Same is the case with CIT appeals. Commissioner appeals has different way of handling the appeals in soft form. So also in the case of assessing authorities. So you have to adhere to all these guidelines that individual files should not exceed a particular size. You cannot upload a particular document in a particular manner. So all those guidelines are required to be adhered to. And once you have uploaded something, just make sure that it is received also, because you get the benefit only if it is received. You don't get any marks for uploading. It is marks are given only if someone, the recipient, receives it. So the receipt, delivery receipt is equally important. One way or another, just make sure that whatever that you have uploaded is received by the recipient. Yes, every communication must be in writing. Even if you are given an opportunity of oral submission, let's say before CIT appeal, we have the framework which says that you can in a given case request for physical hearing, or you can request for the hearing over internet through camera. Supposing authority grants you such a request, it exceeds to your request of granting you the e-hearing. Then also my submission is, my opinion, you have to place on record the entire written submission. You can supplement your written submissions by oral arguments, but you can't rely purely on oral arguments and do away with written submissions, because as per the scheme, it looks that the person who is going to listen to your argument may not finally be passing that order. So someone who is sitting across the camera discussing the case with you may not be the author of your order finally. Someone else would pass that order. And if that person, the person who has interacted with you, if he is not very particular in noting down whatever that you have argued, or if he does not prepare a summary of oral arguments in a proper manner, then probably the author of the order would never know what you argued before the person. And therefore that would be complete waste of time, money and energy. Yes, you, in case if you believe that the summary or the final synopsis are also required of whatever that has been submitted, ask for the permission of such a submission of final summary. Once the hearing is over, you can ask for the permission to place on record a final summary. That would help you in summarizing what all has been argued, questioned, counter question and discussed during the course of the hearing, if at all the hearing is granted to you. That would be insofar as written submissions are concerned. And if time permits, we can, I think I'm almost touching 7:10. I don't want to come in the way of dinner and hungry stomachs. So we can skip this. In case of any questions, any doubts. Yes, yes. Bolo. It is going to be rejected. The question should be that would they grant personal hearing or no? Absolutely. The scheme very categorically says that at their discretion. It is not a matter of right. It is a matter of discretion. So they, in a given case, they may give you, they may not give you. And my personal reading is more often than not, they will deny the request. Absolutely. Personal to મળવાનું તો કોઈ છે જ ના. Video conferencing also is going to be very rare. Look, those powers are kept by the authorities for the simple reason of obliging some, high power persons. Otherwise, other than that, you will not get any personal hearing.
Now, what is the remedy to get original copy records from them? I want to see their records. They will record the results. I know they will not record the results. They are not providing me. I want the original copy records now.
Look, good old days, when GK and drive shaft was not the law, we used to file petitions to get only the reasons. The whole idea of filing the petition is so that we know the reasons. Many a times, after reading the reasons, we will not pursue the petition at all. So the whole idea was to get the reasons. So now probably that time has again come back.
They have given the results.
Right.
I want to check their records. I know that in their communication they have taken the
Wrong facts. Then you can file a reply to the reasons. Objections, in any case, you can file. Against the reasons, you file the objection. There you say that these facts are incorrect.
I can demand the copy of their records.
હવે તો બધું છે જ નહીં, કાંઈ બધું છે એ બધું ડિજિટલ ફોર્મમાં છે. એટલે ડિજિટલ ફોર્મની અંદર શું આપશે તમને? તમે you can always ask for it. You can file an RTI, you can file a petition before the court that these are factually incorrect, or you can file objections against those reasons that these are factually incorrect observations. Supposing they say that so and so is searched, you know for sure that so and so is not searched at all and nothing is found from that person's premises. So this is something which is factually incorrect.
They have said, we have the records with us. We don't want to, we are not compelled to provide.
Right. So that you file a petition. Ultimately, if you don't succeed, then you file a petition. You say that this is factually incorrect, and court would call upon them to justify whether this is factually correct or not correct.
Thank
Yes,
you,
yes.
sir.
Yes. No. No, this was, in fact, what he said was CIT appeal only. CIT appeal માં નથી આપવાના. Right. They are banking heavily on artificial intelligence. Probably what they are not realizing is before artificial, they need to nurture the natural intelligence. So, right.
Sometimes, if you have mentioned about the example of some teachers,
Right.
like in PK, Amir Khan was saying that there are so many meanings of acha. So artificial intelligence is not going to analyze those, facial expressions or expressions or emotions.
Right.
So is there any chance that their system could be having a problem?
Look, what they are going to use the artificial intelligence not for the purpose of entertaining a hearing, not for the purpose of conducting a hearing where your arguments would be recorded. What they are going to use it for is, supposing there is a raw data which is available on the floor of the stock market, let's say BSC, there is a huge data, trading volume is available with them. So they'll ask the computers to find out certain suspicious looking transactions. They may set the criteria that a script which has grown over let's say 500% in last 15 days, you find out what are those scripts. Based on that, they will find out that yes, these are these 15 scripts where there is a more than 500% returns. Then they will find out that who are the persons who have transacted. If the transaction is happening between more than 1,000 persons, then probably it is genuine. But if it is handful of persons who are transacting, then those are suspicious persons. Then they will start the inquiry. So artificial intelligence is probably going to be used on those financial data. Now they have huge data. Supposing you purchase, let's say 50,000 worth of goods every month from Amazon. So yearly you are purchasing 6 lakhs worth of goods from Amazon. Your yearly income is 2 lakhs of rupees. So that is where they are going to, find out. Artificial intelligence is going to be used like this. It's not that they are going to, look, someone was sharing with me a very interesting incident. He was telling me that, sir, whenever there is any card which is given to you for the purpose of accumulating those bonus points, we are very much interested in those cards. So Citibank, Diners, Amazon, all those cards where you accumulate points on various spendings, that would disclose your spending pattern. And if your spending pattern is not commensurate with your income, then you are a suspicious person. Then you are a person of interest to them. And that is where they are going to use the artificial intelligence. So these are the instances where they will come after you. If your trading turnover is huge in stock market, but you are not showing any income at the end of the year, then you are a suspicious person. If your current account has more than 50 lakhs of cash deposited on a year-on-year basis, and your business is such that you can't generate cash, then you are a suspicious person, and that is where the artificial intelligence is going to be used. So not for recognizing the human emotions, so that we are saved for the time being. I don't know when they are going to replace this, but this is where we stand.
Thank you, sir. Thank you very much indeed. I am afraid that's all for the question answer round now. We would have to end the session because we are running short of time. So
With this, yes, I conclude my presentation. I am once again thankful to the organizers for giving me this opportunity to share some of my thoughts on the issue. Stay safe, everyone. Jai Hind.
Thank you, sir. Thank you for your wonderful insights on the drafting and pleading in the era of faceless assessments, appeal and faceless ITTA. On this occasion, we would like to felicitate the committee members for the hard work and dedication at the hands of our eminent speaker, Senior Advocate Shri Tushar Hemani, sir. I request Shri Tushar Hemani, sir, to kindly felicitate our committee members, starting with CA Jayesh Moore, sir, Chairman Publication Committee. I request the audience to please be patient for a while as we are about to end the program for today. Give them a huge round of applause for the dedication and the hard work that goes into an event like this. Advocate Hiren, followed by Advocate Hiren Vakil, Chairman of Media Committee. Next, CA Rutvij Shah, Committee Member, AGFTC. Followed by Advocate Anil Shah, Chairman, South Zone, AGFTC. Followed by Advocate Mahindra Swamy, Chairman, North Zone, AGFTC. Next is Advocate Maulin Shah, Chairman, Central Zone, AGFTC. Followed by CA Maulik Patel, Committee Member, ITBA. And finally, CA Shivam Bhavsar, Co-Chairman, Stage Committee. Let's give them a huge round of applause. Shivam Bhavsar, Co-Chairman, Stage Committee. Thank you, sir. Thank you all. With this, we come to the end of the last session for day one of Tax Conclave. I invite dignitaries to kindly come forward for the group photograph. Thank you all once again for gracing the occasion of the two-day Tax Conclave 2021 on direct and indirect taxes, organized by All Gujarat Federation of Tax Consultants, AGFTC, and Income Tax Bar Association. We once again thank all our conclave supporters such as Indus University, Buy Best, Taxopaid, WIIA, Clear Tax, SBI Cards, Swami Energy, Magnanimous Infrastructure Private Limited, and Travel Sukha. We would now proceed for dinner, and we'll see you all tomorrow at 9:30 sharp for day 2. Thank you very much.